Good morning, sir. You're Justin Living. And Mr. Living was previously here, entered pleas of guilty to the third-degree felony offense of credit debit card abuse and the second-degree felony offense of burglary of habitation. The agreement was for a cap of 10 years to run concurrently on each, citing the PSI, as well as some letters, information that Mr. Kimler sent on Mr. Living's behalf. Has everyone had an opportunity to review all of them?
Yes, sir.
Are there any additions or corrections to the PSI? Mr. Kimler, you may proceed.
Right. PSI.
Mr. Kimler,
What did PSI to the court? Starting this call to put on. See, I was just here working as a while. But you're going to PSI the close discussion. Bunch of issues either repeat or dismiss. I think it looks like what it can is sorry felons if burglary one 1 hour 22 hours probably also more. And then another state jail case was 26. This one got child that's the first glance looks like it was an issue. I wouldn't take issue with the interpretation or recommendations there's issues with serious one looks like felony video drawing just around position for your aggravation. He's looking up the answer to the one thing. Section probation. Boston, right? Church, you need to get out, contact the law enforcement. They were support or support so for one or show the burn situation. So it shows Mr. Frank full range of function 20 years. She has the state job. The credit card. The third, Korea. It's French range. She's taking on Russian and that. Support us, her, and this function range is 20 years. Style promotions and yes.
thank you, Mr. Kimler. Mr. Nickel?
And he has continuously been violating laws. I think we should keep it doesn't this week. And all these other sides. Certain important committees is to change the job for was threatened by this. So we'd be arrested out of the garage. Individual. The homeowner had told
This is where it gets serious. Injury to a child or elderly. That's not a small-time charge. When a defendant's past includes vulnerable victims, judges take it as a huge red flag. Probation suddenly becomes a hard sell.
and he found it. His own explanation was he was one of those sure what that's information. Yeah. Credit card abuse is that she got it from she did. So I don't see how probation will Yes, you do the punishments. And those reporting former grants, the water checks. So I don't see why.
Go ahead, sir. You're not. Mr. Living, I have to turn 3 pages to go through your criminal history. I haven't had an officer make the kind of statement in CSI that I got in this one in a very long time. 83 offense reports have something to do with just phone. Don't know where else you've been, if there's any others. 83. A good person doesn't have 83 police reports that have something to do with me. A good person doesn't assault family members over and over again and get time on misdemeanors and scare them or sweet talk them or whatever it is to get out of it on felonies. That is not a good person. I understand you haven't had probation, but you were barely out of prison and off parole when you did this. I completely agree. I mean, Mr. Himmler has pointed out some decent things, but there is no reason whatsoever that I would put you back on the streets in this community for any amount of time. That makes any sense to me. So in clause number 24, DCCR 0288, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of credit debit card abuse. Sentence you to a term of 10 years in the Institutional Division of the Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to. In cause number 24, DCCR 1100, find sufficient evidence to find you guilty, and at this time find you guilty of burglary application. Sentence you to 10 years in the Institutional Division of the Department of Corrections. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive. These will run concurrently, which means together at the same time. I will sign the dismissal in the other case, which I didn't mention, which is a violation of a protective order where you're supposed to be staying away from money, and obviously you probably weren't. So anyway, that'll get signed. I'm going to hand you in each of your cases the trial court certification that shows that these were agreements that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws to make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to me about. Good luck to you, sir. You can get back to the guy. Good morning. Are you Jacob Kazan? Good morning, sir. You're Alejandro Yuribe. And Mr. Yuribe, you were previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. The agreement was for 5 years, deferred adjudicated probation, and I received that pre-sentence report. Has everyone had an opportunity to review the
83 reports. Let that sink in. That's not just a little trouble with the law. That's practically a criminal resume. And did you catch the part about victims dropping charges out of fear? That screams intimidation. The prosecution knows the jury, or in this case, the judge, can't ignore that pattern.
report? So I guess my issues, or my only issue with going forward with this agreement is your status. You're not here, it appears as though you're not here in the United States legally, and that you've been removed before and there's an ICE hold on you now. Is that correct? So, I mean, what does given a probation do? Just give them a probation and he gets deported and let it go until he comes back again illegally or legally? I mean, there's ways to do it, obviously, legally. But okay. I mean, do you think the best thing is to go forward with the plea? I mean, if you do get out, so let's just do this. We'll just go forward with the plea, and then whatever happens, obviously in federal court or with any type of new charges over there. It looks like I have been handed an arrest warrant from the United States District Court, Eastern District. So I think you will probably be taken from here as a hold on you. You'll go straight over into custody if you're all custody in there. What I'm going to do is go along with this agreement. I'm going to give you a probation. If for some reason you get out during this probation period and you're here in Texas, then you obviously are required to go to probation, do everything you're supposed to, because if you don't, you could end up in prison for a very long time in this case. So what I'm going to do is find that you previously entered a plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, at this time, I'm going to follow the agreement for all proceedings, placed on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation if that becomes an opportunity for you. Obviously, if you do that, in this case, this is an excellent opportunity because you don't have this conviction involved. And again, the other side of that, however, is you do get out and you are here and you do not comply with the conditions of probation, you'll be brought back into this court, found guilty of this offense, and it's anywhere in the range of punishment was up to 20 years in prison. Do you understand? I am handing you the trial court certification that shows this was an agreement that I followed, and so you've waived the right to appeal. Probation will go over your documents with you today, and then we'll see what happens. All right? You can Coleman, thank you. Good morning. Are you Demetrius Miles? And will your client waive the formal reading of the indictment? Mr. Miles, in cause number 24, DCCR 2478, you're charged with second-degree felony offense of aggravated assault with a deadly weapon. That's from November 26, 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand that? And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving, giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's submitted with Mr. Miles. Is there any evidence of Mr. Miles not being competent? All right, sir. I'm going to find that you entered the plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in your case. I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can tell me. All right, good luck to you, sir. You go back with bailiff. All right, are you Gabrielle Smith? And Ms. Smith, you were previously in court and entered a plea of guilty to the second-degree felony offense of robbery. The agreement was for a cap of 5 years in the Institutional Division of the Texas Department of Corrections. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yeah.
Cap judges are married to the court. Usually for as long as the robot is there. Hopefully you have it.
now history I just give you the draft one based on the DIC I had obviously the songs information. I'm not sure that coupled with the behavior,
No, I it's not. Yeah, I don't think it is either. So, Ms. Smith, I mean, your criminal history is pages and pages long. Hold on. You have felony 1, 3, 4, 5, 6, 7. You have 7 prior felonies for theft of goods.
I was one of the police for you say, no, I'm not sure. Well, some of them will. Well, first page, the third, well, not third, it's not. Call here three, but I think that's
Okay. Let's
so that's what
And here comes the hammer. The judge is crystal clear. A good person doesn't rack up 83 reports. It's a brutal takedown, but this is courtroom reality. History matters more than promises. Once you've built that kind of record, second chances become nearly impossible.
five down.
Well, the very top one is a year in Department of Corrections.
That was all.
I was on my thing from you know on it me.
So let's take one of those out that it's missed. Okay. Take 1, 2. So it's 4 or 5. 1, 2. Just because they ran at the just because your time ran at the same time doesn't mean that you weren't out there committing the same thing. Don't talk over me. Over and over and over again. The misdemeanors alone, I've got at least 8 theft misdemeanors, at least 4 stand up. At least 4 felonies. I'm not going to accept the agreement for a cap of 5 years. I do not think that is appropriate in your case, based on the nature of this offense, based on your underlying criminal history, based on jail incident reports that I've received. So I'm rejecting that offer, which is allowing you to withdraw your plea. I'm going to reset your case. You guys can negotiate. If y'all come up with something different that the state thinks is appropriate, then I will look at that at that time. You can go back to the table. You have a whatever. Your bond is set at $7,000. That's No, I'm withdrawing the PSI bond at this time. I am finding, based on the information that I have received in your pre-sentence report, that is insufficient. And at this time, I'm raising your bond to $40,000. You can go back with the Well, what we didn't know, and what I didn't know, and what Ms. Malfino didn't know at the time that this offer was made, was the extent of your criminal history in Louisiana. So go back with the what? Yes.
She told me that I was reunited for all the police. Not understand. Yeah.
Hold on. And when someone else, I let you talk. So when someone else is talking, you let them talk. All right? That's respectful for everyone. I gave you an opportunity to let Mr. Malfino answer.
Underlying
All right. Mr. Rojas will go over all of that with you. You can go back with the bailiff. Miss Smith, come back. Miss Smith, come back in front of, come back. You cannot understand, but you're going to be respectful in this court. You're not being respectful. Because I think you do understand, because this isn't your first time being in a court of law. You've been in numerous times in Louisiana. Alright? When you walk out of here, you walk out quiet, no attitude, because things can get worse and worse and worse instead of better and better and better. Right? Go back with the bailiff. Let's try it again.